2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay. And on behalf of Judge Bennett and Judge McBrayer, we welcome counsel to this oral argument, which we are live streaming to the public to fulfill our obligations to maintain our open courts. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you has 15 minutes, and the appellant has reserved time for rebuttal, and so we'll program the clocks accordingly. Unless there are any announcements, we will ask Ms. Lindsay to call the case.
Tennesseans for Sensible Election Laws versus Herbert H. Slatery III et al.
All right, the appellant has the floor.
May it please the court. My name is Alex Rieger, and on behalf of the Attorney General, I'm here in defense of the challenge statute. The Chancery Court's decision should be reversed for 3 reasons. First, the plaintiff lacked standing to bring their constitutional challenge. Second, the Chancery Court lacked subject matter jurisdiction to declare the constitutionality of a purely criminal statute. And third, because the statute itself survives constitutional scrutiny. Given the wide scope of this appeal, I would like to use my time at argument to emphasize certain points regarding the threshold issues of standing, the inapplicability of the statute to plaintiffs, and subject matter jurisdiction, and I'll rely upon my briefs for the remainder. To start, the challenge statute, Tennessee Code Annotated 2-19-142, is a purely criminal statute. It does one thing and one thing only. It creates a Class C misdemeanor for any person to publish or to distribute campaign literature in opposition to a candidate if the person knows that that statement is false. The current version of the statute was enacted in 1974, and that brings us first to the issue of standing. Despite being in effect for 47 years, plaintiff has not identified any prosecution that was brought pursuant to the statute, not a one. Now, at trial, the parties and the Chancery Court agreed that the Sixth Circuit case of McKay versus Federspiel applied, since this was a pre-enforcement challenge implicating the First Amendment. Under McKay, one of 3 factors has to be met in order for standing to be present. Either you need 1, a history of past enforcement against the plaintiffs or others. 2, you need enforcement warning letters that are sent to the plaintiffs regarding their specific conduct. Or 3, you need an attribute of the challenge statute that makes enforcement easier or more likely. And historically, those provisions have been instances where any member of the public is allowed to initiate an enforcement action, sort of creating a mini attorney general charged with enforcing the statute whenever they would have a cause of action. The Chancery Court here found that only factor number 1 was present. There was no disagreement from the parties that factor 2 did not apply here. Plaintiff received any enforcement warning letters regarding their specific conduct. Plaintiff argues and argued below that factor 3 was present, but the trial court did not rely upon it. So I'll start with factor 3 and why the Chancery Court was right to not apply it here. And that is that there is no attribute within the statute that makes it more likely to be enforced. The public is not empowered to bring an action pursuant to the statute, and one would assume that if the statute had any sort of novel attribute that made enforcement easier, then the parties would be aware of some enforcement of the statute rather than a 47-year drought of prosecutions. So the Chancery Court was absolutely correct to disregard and find factor 3 inapplicable, which leaves only factor 1, the factor that the Chancery Court relied upon to find that the plaintiffs had standing. The Chancery Court was incorrect in doing so because factor 1 doesn't apply here. Plaintiffs in their trial court pleadings pointed to a list of places where the statute was referenced as evidence of enforcement, and the Chancery Court took that bait. But that was wrong because there's no indication that the statute has ever been enforced as intended and as the plaintiffs fear, according to their complaint. If plaintiffs were correct that references to the statute in civil matters could confer standing, then any criminal statute could automatically grant plaintiffs standing in all applications because any criminal statute can be used in myriad contexts. Criminal statutes can be referenced in divorce proceedings, terminations of parental rights proceedings. A number of different things allow reference to criminal statutes, but here, plaintiff challenged it because they feared enforcement. And in this case, where we have a 47-year drought, of prosecutions where this statute has never been criminally enforced, and where we have submitted a declaration of the Davidson County District Attorney's Office, which is the only defendant that had the authority to prosecute violations of the statute. General Funk's office said, and he was very unequivocal and clear about this, they had no intention of prosecuting plaintiffs for the conduct they wished to do under the statute. Two, they had no interest in prosecuting anyone under that statute. To put it plainly, they were not going to disrupt the 47-year drought of prosecutions. There was not going to be a criminal prosecution against plaintiff. And thus, because there had never been a prosecution shown, and because General Funk's office had explicitly and expressly disavowed any prosecution that would fall upon plaintiffs in this case, there's simply no standing because plaintiffs don't have a bona fide fear that the statute will be prosecuted against them and the way that they pled in the complaint. Now, plaintiff argued against the lack of prosecutions and the disclaimer by General Funk's office in two ways. First, the plaintiff argued that he had statutory standing, and that statutory standing excused the lack of constitutional standing, and that's wrong. It's based on a fundamental misapprehension between those two concepts. Tennessee's Supreme Court recognizes both constitutional and non-constitutional standing, and that's the City of Memphis versus Hargett case, that's ACLU versus Darnell. It's not in contention here. Non-constitutional standing is what we sometimes refer to as prudential standing. It's a question about whether or not this is the time and the case for the court to hear this particular issue. Constitutional standing is justiciability, and it's very similar if you look at the ACLU versus Darnell case, the Worth versus Selden federal case. Article 3 standing and Tennessee's constitutional standing are basically the same thing, and they concern themselves about justiciability. That standing, constitutional standing, cannot be waived, and it's an irreducible minimum. Simply because a statute, as plaintiffs claim with their statutory standing argument, simply because a statute provides them a cause of action, that statute cannot negate or reduce the requirements of constitutional standing. What the Tennessee Constitution says is required in order to bring a case, the legislature cannot reduce. Neither can the court, neither can the executive branch. What the Tennessee Constitution says is a requirement. And for any of the branches of government to attempt to reduce or negate that constitutional requirement would violate the separation of powers. This means that the legislative creation of a cause of action, like the Declaratory Judgment Act or TCA 13121, just because that's available to a plaintiff does not automatically give them license to sue at any time. Constitutional standing has to be present in all cases. Second, plaintiff argues that in First Amendment challenges, the court should not closely scrutinize standing. But in every case the plaintiff cited, those statutes did not have a history of non-enforcement. They did not have a voluntary declaration by the district attorney's office coupled with a drought of prosecutions. The statute is, for lack of a better word, moribund. It's simply, when you couple the history of non-enforcement with the declaration of the Davidson District Attorney General's office, there simply is no credible fear for plaintiff that it would be prosecuted, and thus it has no standing. Likewise, standing is also not present because the injury of which plaintiffs complained is not redressable by the Chancery Court in this instance. It is well settled in a number of Tennessee Supreme Court cases that a Chancery Court cannot enjoin the enforcement of a criminal statute. It simply can't. That's Davis Kidd, that's Clinton Books, that's City of Memphis and City of Chattanooga. And we know that because the Chancery Court could not issue an injunction, even though it declared the statute unconstitutional, that declaration doesn't accomplish anything because the District Attorney General could still go out and still go after Teasel and still go after the plaintiff in this matter and bring a criminal prosecution in front of a criminal court who is free to disregard the holding of a sister court. And for that reason, under the California versus Texas case, as well as City of Memphis and City of Chattanooga, because at no point did the Chancery Court's declaration affect the relationship between the two parties and control that relationship as to what action the District Attorney General could bring, the matter is not redressable and thus there's no standing. The plaintiffs also lack standing because the statute is inapplicable to them. The Chancery Court, at the plaintiff's urging, chose a construction of the statute that was extremely literal, against the common understanding of what the statute was designed to do, and it chose the construction that was most likely to doom the statute into unconstitutionality, which was wrong. We know that under Tennessee Supreme Court precedents that if there are two constructions of a statute that both make sense, the court must choose the one that sustains it rather than dooms it, and that is the Davis-Kidd case. The statute's purpose is to prevent the knowing expression of factual falsehoods. The context in which plaintiffs brought the case was satire and parody. Satire and parody are not factual. They just fall outside of the statute. For something to be factually false, it has to necessarily be capable of being perceived as true by a rational person. For instance, Jonathan Swift's A Modest Proposal. That's not taken at face value. No one believed that he actually intended to propose using our young as food for the wealthy. So it's not false. It may not be true, but it's not false because it can't be perceived as true by a rational person. Here, no one can believe that a human being could survive with cauliflower instead of brain tissue. That's simply unbelievable. Likewise, no one can be so confused about the proper timeline to think that a person who's alive now could be Adolf Hitler. Those are satirical metaphors. They're not factual. They're not falsehoods. They simply fall outside the scope because they're not capable of being perceived as true. The statute should have been construed this way because to do so not only obviates the constitutional challenge, it's the more correct reading of the statute. Simply to take so literally that satire and parody, things that cannot be perceived as true, fall within the statute's ambit is a strained construction that's designed to harm the statute rather than sustain it. Lastly, I'd like to talk about subject. I see I'm running out of time. I'd like to talk about subject matter jurisdiction. This matter was brought pursuant to the Declaratory Judgment Act in 42 U.S.C. 1983. Neither cause of action allows the Chancery Court to declare the constitutionality of a criminal statute. The Declaratory Judgment Act says that the power to declare statutes falls within courts within their respective jurisdictions. Under the Memphis bonding case, which we cited in our brief, which is binding upon the parties in accordance with Tennessee Supreme Court Rule 4G, solves the dispute between Blackwell and Carter, because that case says that the Supreme Court's decision in Zirkle remains good law, and any attempt to deviate from it using the Davis-Kidd or the Clinton books holdings of the Supreme Court is wrong because neither one of them expressly contemplated the question of subject matter jurisdiction. At the end of the day, the Chancery Court only has jurisdiction to grant a declaratory judgment if it has jurisdiction over the underlying matter. And this statute only criminalizes conduct. Chancery courts do not have subject matter jurisdiction over criminal matters, and therefore the Chancery Court lacked jurisdiction to enter the declaration here. And I'm out of time unless the court has any further questions.
Thank you, General Rieger. Mr. Horowitz.
Good afternoon, Your Honor. Daniel Horowitz of the Nashville Bar on behalf of Tennesseans for Sensible Election Laws. I also want to take a moment to recognize my co-counsel, Professor Hans, and his students at Vanderbilt Law School's First Amendment Litigation Clinic for their invaluable assistance litigating this case. Your Honors, this case presents a constitutional challenge to Tennessee Code Annotated 219-142, a statute that criminalizes speech about politicians based on the viewpoint expressed and the medium of expression used to speak. I'd like to spend most of my time answering the panel's questions, but before doing that, I just want to address a few things that I heard from opposing counsel in the opening argument. The first was that this is purely a criminal statute. That is going to come as a surprise to a lot of people, including this court, which has enforced this statute in a civil context. That's Jackson versus Shelby County Civil Service Merit Board, in which it upheld the termination of a public employee following a Loudermill hearing on the basis that the public employee had violated this statute. The statute has been enforced criminally by a district attorney who sent a criminal threat letter. It has also been enforced civilly on many occasions, including against one of the plaintiff's own agents and attorneys in civil proceedings. It's been used as a basis for obtaining injunctive relief by a campaign for a U.S. congressman. The instances of enforcement which the appellants characterize as non-existent are in fact robust. Criminal and civil, private litigants, as well as public officials in agencies, in courts. This statute is nothing resembling moribund, and all that you need to do is read the Attorney General's own fairly recent opinion indicating that criminal prosecutions under this statute, including against newspapers, are perfectly appropriate. I also heard opposing counsel say that this statute has never been criminally enforced. The record does not support that representation. The record contains evidence of a district attorney sending a criminal enforcement letter. And also, the appellants have never attempted to prove that this was not criminally enforced by other district attorneys. One district attorney indicated that it does not have a non-enforcement policy. The fact of the matter is that the plaintiffs identified multiple instances of both criminal and civil enforcement that clearly demonstrate that they have standing to prosecute this case. That's it. The instances identified.
What's the effect on the DA of Davidson County saying he had no intention of enforcing this? Does that affect your standing?
It does not. Let me push back on that a little bit. That declaration, which by the way was submitted days before summary judgment, not at the outset of this case, is a representation of a present partial intention not to enforce the statute in a very, very narrow context. It does not bind the office permanently. It's not even a wholesale disavowment of enforcement authority. It was specifically calculated to basically defeat standing on the eve of summary judgment, but also it has no application on other district attorneys across the state of Tennessee. That's something that we've raised repeatedly here. Anywhere that the plaintiff's campaign literature is distributed, the plaintiff is subject to potential criminal prosecution or allegations of criminal impropriety, which are their own injury. It also prevents recipients of this literature from republishing it for fear that they will be prosecuted, and prevents newspapers from carrying it because the Attorney General has made clear in the most formal possible terms that there is no constitutional obstacle, in their opinion, to criminal prosecutions against newspapers that carry affected literature. As a result, the idea that this statute is moribund is frankly farcical, and the idea that it has never been criminally enforced is also disproven by the record. I don't know how else to characterize a district attorney sending a criminal threat letter to someone saying your conduct violates this criminal statute other than criminal enforcement. Opposing counsel also said that General Funk is the only office who had authority to prosecute the statute. That is simply not true. Any district attorney in Tennessee can enforce the statute. Any law enforcement officer presumably can make an arrest under this statute. None of those people have indicated that they will disavow enforcement of it. And again, the Attorney General has advised all law enforcement officials across the state of Tennessee that enforcement of this statute is constitutional in its opinion. Last, the idea that the order that was entered here doesn't accomplish anything is simply false. It declares the plaintiff's rights. That's the entire purpose of a declaratory judgment action. With that, I do want to emphasize one thing that we did not, or that opposing counsel did not touch upon, which is the standard of review that applies to a declaratory judgment action. The correct standard of review, which does not appear in the appellant's briefing, is abuse of wide discretion. That comes from State Ex Rel Monsieur v. Jones. The holding there is the decision of whether to entertain a declaratory judgment action is discretionary with the trial judge, and this discretion is wide. It goes on to say that absent an abuse of discretion, a trial court's decision to grant or deny declaratory judgment should not be disturbed on appeal. And this standard of review is dispositive of this appeal because the material facts underlying the trial court's decision to grant a declaratory judgment in this case are not only undisputed, they are unchallenged in this appeal. Those facts evidence a lengthy history of enforcement of this statute, including, and again, I cannot emphasize this point strongly enough, by this court in a case in which it upheld a public employee's termination for violating the statute. They evidence enforcement civilly against political organizations, that were sued for violating the statute. They evidenced multi-million-dollar lawsuits against citizens for alleged violations of this statute. This statute is simply not more abundant. Beyond the facts evidencing its enforcement, I also note that last year, after recent attempts to raise the criminal penalty associated with the statute by members of the General Assembly, the fiscal note that was drafted in reference to that proposed legislation assumed some number of continuing prosecutions. This is not what a moribund statute looks like. And I agree with Your Honor that if at the very outset of this matter, the Attorney General had come out and said, we are simply not going to defend this statute, there is nothing to litigate here because we take the position that it's moribund and that nobody should enforce it, that would be one thing. They in fact have done the exact opposite. They have continued to defend the constitutionality of the statute, and they have never altered their still active guidance through a published Attorney General opinion that prosecutions under this statute are valid, including against newspapers. Beyond that, I do want to touch upon the proposed limiting construction here, which is impossible. This statute is content-based, has content-based infirmities and viewpoint-based infirmities. In other words, it applies exclusively to politicians, and it applies exclusively to campaign literature. It also discriminates on viewpoint in that statements in opposition to politicians are criminalized, while all other false statements are permitted. In order to deal with those content and viewpoint-based infirmities, this court would have to expand dramatically the criminal scope of the statute to apply it to everyone. That is simply not within this court's authority. You can't rewrite the statute to say it is a criminal offense for anyone to make any knowingly false statement against any person, which is essentially what you would have to do to deal with the content-based infirmities here. I also have yet to understand what the compelling interest the government is asserting the statute promotes. During the briefing below, they didn't raise one. They raised one for the first time during oral argument that they have since abandoned in this appeal. My best reading of their briefing is that they think that the government's compelling interest in regulating defamation can sustain this statute. Your Honor, it cannot. The statute makes the further content discrimination of applying only to politicians and only to campaign literature. That itself has to satisfy strict scrutiny. The statute does not. The number of defamatory statements that escape regulation under the statute is legion, and the application of this statute is too narrow to support the interest that the government has proffered here. So with that, Your Honors, I'd like to answer any questions you have about the briefing.
I've got a question, Mr. Horowitz. What is the practical effect of the trial court's ruling? By that, I mean, is the state precluded from prosecuting someone under this act?
The practical effect is to declare affirmatively that the plaintiffs have a right to continue distributing campaign literature that runs afoul of this statute, something that they have done in multiple different election years and will continue to do. It is a declaration of their affirmative right to do it because the statute is unconstitutional.
All right, thank you. Any questions for the panel? Hearing none, thank you, Mr. Horowitz. And don't want to cut you off, but are you through?
Unless this court has some additional questions, I'm mostly done here. I do want to flag the fact that very recently the Attorney General's office has attempted to say that Article 3 jurisprudence from the U.S. Supreme Court should control this case based on a couple of recent opinions up there. I think that is a difficult position to take for several reasons. The most straightforward one being that Article 3 contemplates no limitation on enjoining district attorneys regarding state statutes. The Attorney General can attest to this. Just a couple of weeks ago down the street, the Davidson County District Attorney and Hamilton County District Attorney's Office were enjoined from enforcing a speech-based unconstitutional statute related to the compelled bathroom speech law. Article 3's subject matter jurisdictional limitations are different. They are more favorable in some ways and they are less favorable in some ways. But they certainly do not apply. The U.S. Supreme Court has made clear that they do not apply. And the Declaratory Judgments Act and Tennessee Code annotated 13121, which are the sources of state statutory authority that permit this action to go forward, are constitutional. Frankly, the number of cases that this court would have to rule or to overrule in order to adopt the Attorney General's position here that you can't reach the merits of this case is significant. I would have to overrule Judge McBrayer's opinion from 2018, Grant versus Anderson. It would have to overrule opinion from a year and a half ago when the same parties and attorneys were before this court and Tennesseans for sensible election laws prevailed. It would have to overrule Campbell v. Sundquist, where a declaration of a criminal statute was upheld. Clinton books allowed the declaration to move forward. Irwin Billiards allowed the declaration to move forward. This is well settled, Your Honor. To the extent that it wasn't, the legislature's recent enactment of 13121 makes clear chancery courts have subject matter jurisdiction to adjudicate these claims. This presented a live controversy implicating not only the plaintiff's rights, but the rights of all third parties and the public to hear what the plaintiffs had to say. This statute restricts the plaintiff's speech. It restricts the reach of the plaintiff's speech by preventing newspapers and other individuals who receive it from republishing it. These are real injuries, Your Honor. The state's very restrictive notion of what an injury is, basically, until you are shackled and prosecuted, you have not been injured. The statute is under the statute is wrong. This court should affirm the Chancery Court's ruling, and it should also award attorney's fees for this successful piece of constitutional litigation. Thank you, Your Honor.
Thank you, Mr. Horowitz. General Rigger, your rebuttal.
Yes, Your Honor. To start, I'd like to note that when Mr. Horowitz made the comment that I had somehow misled the court regarding who had enforcement authority, my statement was that there was only one state defendant in this case who had enforcement authority over the challenge statute, and that state defendant, General Funk, explicitly disavowed that he would pursue criminal charges against the plaintiff. And that's really what's at issue here. Plaintiff is attempting to obfuscate and muddy the water with regard to instances in which the statute was invoked, but not as it was legislatively created to do, and not as it actually operates by its plain language. You take the plaintiff's argument at face value, then any reference to it, any oblique reference to a statute automatically gives everyone standing, and that simply is not the case. Here, plaintiff filed suit out of an alleged fear that the statute would be used to criminally prosecute them for satire. The combination of the fact that there has not been a successful criminal prosecution under the statute, there's not been an indictment brought under the statute, as well as the District Attorney General's offices, the only one that was sued based upon the bounds of the complaint, disavowing any attempt to use the statute against plaintiff, renders their fear no longer reasonable, which means
Does this apply to federal elections?
Oh, what was that, Your Honor? I apologize.
Does this statute apply to federal elections?
Your Honor, I believe that this statute, does not speak to state or federal elections.
That's why I asked.
Yeah, yes, I believe that it does not speak to either. If I could,
does that mean it applies to both?
Your Honor, I've not studied the wide ambit of federal election laws to know if there'd be a supremacy issue there.
Okay.
Would it apply to the election of the president of the PTA of Wilson County?
Your Honor, again, it affects state law, given that election would be a state election. The statute the statute does not specify what its limitations are.
But to this point, no candidate for the PTA or newspaper has been prosecuted.
Your Honor, to this point, nobody's been prosecuted. It's been 47 years and we don't have one. One thing I would like to note with what's left of my time is when plaintiff mentioned the standard of review being a wide abuse of discretion standard, that's simply incorrect. As we all know, a declaratory judgment act is a prudential decision. If a chancery court gets broad a declaratory judgment action, then they can choose not to as a prudential decision. They can say, no, I don't want to right now. But when you have threshold requirements for exercise of jurisdiction, like standing, subject matter jurisdiction itself, those are interpretations of the statute. Those must be reviewed de novo because they are pure issues of law. And I see that I've run out of time. If the court has any further.
All right. Thank you, General Rieger and Mr. Horowitz. This is a very interesting case, and we'll give it our very ardent review. Please, Ms. Lindsay, please conclude the case.
This Honorable Court of Appeals stands adjourned.
Thank you. And counsel, you are free to exit the Zoom meeting.
Thank you, Your
Thank you,
Honor.
Your Honor.